Hello, I'm Laura Natale, Tech Media Telecom Mobility Director for the Centre on Regulation in Europe, CERRE, and it's my pleasure to welcome you to the Digital Services Act webinar within our rendezvous series, which kicked off back in January. Now, I read in Politico this morning that another webinar on the DSA was happening today, but this one, challenge accepted, I can assure you now, that is not just going to be any other discussion. We don't plan to repeat top level lines on the DSA that we've been hearing over the past months, because we've now all had time to think about the proposal in some depth. So our focus as the independent Brussels think tank Advancing Regulatory Practices is rather on how different legislative frameworks interact one with the other. Rewinding a few months, CERRE published its DSA recommendations in early December 2020, so soon before the Commission had adopted its proposal. Those recommendations remain available via our website, cerre.eu, and you'll hear them referred to today. Because we are now in a transition phase in terms of regulation in the digital world in general, but certainly on content regulation, where several instruments were revised or established at the initiative of the Juncker Commission, and all underpinned by the markedly not revised e-commerce directive, we're going to start our debate from the assumption of accepting that there will be a Digital Services Act to DSA. So more or less agreeing on the what and fine-tuning the how, noting that there is regulation also under the digital single market, some of which has only recently come into effect. So if we think of the recast Audiovisual Media Services Directive, or even regulation addressing terrorist content online, where political agreement took a good while into this Commission mandate to reach, the GDPR, e-privacy, we're in a situation where more rules are still on their way that businesses and regulators are preparing for. So it might also be important to specify ahead of us kicking off this discussion that CERRE, when we started this study last year, we were looking at the Digital Services Act in its full guise. So we carried out research on the economic pillar of what was then conceived as the DSA, and that has since become known by all as the Digital Markets Act. And the non-economic pillar, so more speech, content focus aspects, which are now encompassed by the DSA. But it does mean that today we're talking primarily about services type content rather than goods. And this webinar is indeed subtitled as Platform Services and Media for this very reason. So to outline the structure of today's discussion agenda, CERRE Research Fellow Sally Broughton-Micova will talk through both her CERRE paper recommendations and how she sees this fitting in with the Commission's proposal that Member States and the Parliament are now negotiating in co-decision. We also have the paper's co-author, CERRE academic co-director Alexandre de Streel on the line, and he might jump in. In line with the series signature of this rendezvous series of providing you with a transatlantic perspective, we have Eric Stallman, Assistant Clinical Professor of Law and Associate Director of the Samuelson Law, Technology and Public Policy Clinic. Eric is also Faculty Co-Director of the Berkeley Center for Law and Technology. And then we'll move to an industry and regulators panel comprising Facebook, Snap, Vodafone, Ofcom and Agicom. I'll introduce their representatives after Sally and Eric's first remarks so that the panel can react to the academic views and more. And hopefully we'll also have time for our academics to close off with their key learnings from the panel. As ever, we'd like you, our viewers, to get involved today. The DSA has been a long-awaited initiative and announced very much as solving some outstanding gaps in EU law. But we're keen to make space for a variety of further questions, so you can submit these via Slido using the hashtag CERREDSA or scanning the QR code that appears on screen. I'll put questions to speakers as always as appropriate moments arise during the discussion. In terms of what's next from CERRE after today, these events are all feeding into a high-level closing session to end these series, and we will announce details on this in the coming weeks, but we're looking at the date of the 4th of May in case you want to note it down in your diaries now. Lastly, we warmly encourage you to sign up to the free CERRE newsletter. You'll find details in the box below if you're following on YouTube or on the CERRE website, cerre.eu. Now over to Sally. So Sally, hello. And the CERRE recommendations, which we worked on over several months, were focused on clarifying responsibilities for digital services. And you'd looked a lot from scope all the way to enforcement. And you made suggestions at very practical levels, mechanisms for determining jurisdictions, designating representatives on EU territories, streamlining the input from member states authorities upstream to the Commission. So how now in March 2021 do you look back at this work, taking into account the Commission proposals, the evolving regulatory environment on the edges of the DSA, as I mentioned a few moments ago, and what do you see as important to note moving forward?
Thank you, Laura. Well, I want to take a step back so we remember, firstly, why we're doing this at all. And if we think about 2000, the e-commerce directive set out exemptions from liability for services. As long as they are mere conduits, they are just hosting or caching with no knowledge of what they're storing on behalf of users or sharing, what users are sharing and doing with these services. And that was working, and there's a lot about it that still works, right? And so I think one of the great things is that this directive is not trying to undermine completely that fundamental framework of exemptions from liability. What we did see, though, is since 2000, a proliferation of illegal content and behavior online, lots of headlines in the press moments, pressure from advertisers and users, and I think also legitimately, an interest from the platforms to be able to provide a good experience for the people who are using them. And another thing is that we saw a lot of automation in this space. So one thing that really wasn't a consideration at the time of the e-commerce directive, which depends on the idea that users let the platform know that there's something there that shouldn't be there, that's something illegal, and the platforms then have knowledge and they do something about it. Well, the services are dealing with billions and billions of pieces of content, millions of users all the time. So that kind of relationship isn't the key thing that's actually protecting us from illegal content anymore. What is algorithms. Most of the stuff that is getting taken down, identified as illegal, it's being done automatically. So if you look at the transparency reports that we do have from the largest services, it's in the 90s percentiles of content that is being identified before users even see it. So we had to take into consideration a little bit of what's going on here. Another thing that is happening is, as you mentioned, Laura, the surrounding regulatory environment has been changing. So we saw a lot of action, firstly, in relation to copyright, that kind of picked at this element of the e-commerce directive. And then we had the revision of the audiovisual media services directive. And I looked at that as kind of the pilot almost for what could happen in digital services. I mean, video sharing platforms are specific, and I think it's right that there are sector specific rules for video sharing platforms. But you can see in the kind of approach that the AVMSD takes that we're looking for establishing a different kind of responsibility. Right? And that's one of the big, I think, innovations that the AVMSD did, was establish this responsibility that is not editorial responsibility, that doesn't go along with the same kind of liability and expectations that we would have. But so when Alexandre and I were doing our recommendations for what we wanted to see in the DSA, I think a lot of that was in the background, and we could see stuff that was going on in member states that are, trying to protect users, trying to combat illegal harms. And I think what we wanted to do here was kind of, in our recommendation, step back and say, okay, what would be the key things to take forward? And the first thing is to remove the disincentives for services to take action, right? We need services to feel comfortable being able to take preventive actions, putting these algorithms in place, devising systems without losing their exemption from liability, right? And we saw that in Article 6. We see a Good Samaritan clause now in place. I would say perhaps it needs a little bit more detail because right now it's sort of voluntary action. You know, it's a bit vague, and I would say there's probably a need for a bit more clarity for services to really know what's going to count in terms of, you know, a voluntary action and what constitutes actually having knowledge of the content, right? And so there's probably going to be some lines there that need clarification. And the other, I think the most important element of our recommendation is that the focus needed to be on procedural accountability. What we don't want is what we see happening in some other countries where you know, governments are trying to tell services what can and cannot be on the platforms in a really minute degree, and where we have straying into all kinds of other things rather than just illegal content and behavior. And so what we meant by procedural accountability is we need platforms to be taking responsibility for the processes through which they're going to be trying to prevent illegal content. And we see that reflected in the DSA in its due diligence approach, right? This is essentially a procedural accountability, I think, that is there. Another thing that we really recommended was proportionality. In the end of the day, not all services carry the same risk, right? And we also made size a massive factor of that. And as you say, we were also thinking DMA at the same time, where size is certainly an issue. It's not the same thing, but in relation to content, in relation to digital services, what's now in the Digital Services Act, we were also thinking about the character of the services and their functionality. And I think Christel Schaldemose, I would probably mispronouncing her name, so I hope she forgives me, but she's the rapporteur for the European Parliament, and she also pointed out there's some kinds of services that are a critical infrastructure now for political debate, right? They have become essentially public spaces, and so we need to be thinking about guaranteeing rights for users in a different way when it comes to this kind of public space critical infrastructure for our society and for democracies. And so the DSA does establish this category of very large platforms, right? But the way it defines them is by user numbers, right? And so I think we need to look a little bit more. There's some language in the DSA as to character, but I think I would really like to have a bit of more of a discussion about how we're defining this kind of special category of high risk services. In our recommendations, the last thing that I'll mention has to do with kind of the institutional design. How is all of this going to be monitored and enforced? And we certainly did see that there needs to be some European level role here. There's and there needs to be quite clearly defined processes for dealing with derogations to country of origin, the conditions under which those derogations can be done, and coordination. And there's quite a lot of detail in the DSA, and I hope we get to talk a little bit more. I'm quite interested today in hearing from the regulators that we have what they think of the system that is laid out for dealing with that, and the platforms now. Is it clear you know, where we're going to allow derogations under this system or not? And I'll leave it there so that we have more time to hear from everyone, and I hope we can pick up these points in relation to institutional design and how that's going to function for enforcement.
Thank you so much, Sally. Yes, we'll definitely be picking those up during the panel, and I think it will complement nicely as well the thinking we've done on institutional design, both within the DMA and more generally in terms of CERRE's recent regulatory oversight work. So thank you very much. Eric Stallman, good morning. And thank you for joining us from the West Coast before the sun has even risen, if I understand correctly. We're aware, Eric, of your open internet and freedom of expression work. So we're very pleased to have you here today. It's certainly very relevant here in Europe when where we're looking at a delicate balance that we're seeking to strike between preserving the right to freedom of expression and preventing and protecting from harm. And we're very interested to hear from you because some say the US has a regulatory vacuum in this area. And even though we know in particular, if we think of events from earlier this year that were watched keenly worldwide, about the voluntary codes that some of the platforms apply. We know, of course, of the ongoing Section 230 reform conversation, many federal, many local proposals. And I'd like to now give you the floor and understand if you have any views on the CERRE approach to recommendations to the DSA, but also a bit more insight into what you think US decision makers and stakeholders are looking out for within the DSA debate here in Europe, and of course their own plans.
Great. Yeah, thank you very much. And I just want to first say thank you for inviting me, and also just to commend Sally and Alexandre on what I thought was a very thorough and very helpful report as we try to sort of make sense of this space. And yeah, I'll touch on a few areas that it'll cover some of the same ground that Sally mentioned, but that relate really to sort of the US perspective on the DSA, both from the standpoint of the entities that might have to comply with it, and also the standpoint of both regulators and civil society groups that are sort of thinking about what is going to happen with content moderation in the United States. And so obviously these views are not monolithic. Not all companies see this the same way. Not all civil society organizations see this the same way. But I think just to acknowledge the point that you mentioned, that I don't know if everyone would agree that was a regulatory vacuum, but definitely the center of gravity on sort of regulation of these, not just these questions, but also privacy, and to some extent copyright as well, has sort of shifted towards Europe. And given how much interest there is right now in the issue of intermediary liability and content moderation in the US, I imagine that the DSA will have a lot of influence over some conversations there. I'll sort of focus on three areas that again that Sally sort of touched on, but offer a few more thoughts. And I'll start with the issue of proportionality. One thing that I think is generally well received is the idea of a recognition that not all online services, not all platforms, it's not just a matter of posing the same risk, but also what they're capable of doing and what obligations they're capable of complying with. And I think there was a lot of concern in sort of conversations about regulatory requirements in this space, that they might become a sort of a means of foreclosing competition, because not all platforms would be able to adopt the same measures. And you saw some of these conversations happening in the context of the Digital Single Market Copyright Directive, particularly with respect to Article 17. But one thing I think is well received here is the idea that certain platforms are held to different, not standards, but different mechanisms for fulfilling them. I think there are questions about where the line is appropriately drawn. I believe it's currently at 45 million users, and is that the right threshold? And also, even among services that meet that threshold, should there be further differentiation? And so I think that'll just be more area that is sort of scrutinized in terms of where lines might be drawn over here. And then just to touch on transparency and accountability, and sort of 2 points that Sally mentioned that I think are really important. One is this issue of automated decision making, and just the role of algorithms in performing just so much of content moderation now, and the idea that if you're going to have some sort of meaningful ability to contest the results of the sort of those automated decisions, as the DSA seems to contemplate, you do sort of need to have some information about how those decisions are made, and there seems to be a pathway in the DSA to provide that information. And I think this is just very interesting, not just for content moderation and online intermediary liability, but for just these larger questions of sort of algorithmic governance. So that was interesting to see in the proposal. And then Sally mentioned this point about the Good Samaritan clause in Article 6, which definitely has got a lot of attention as sort of the obligations of Good Samaritans in the U.S. are sort of being scrutinized in the context of the debate over Section 230 of the Communications Act. And she pointed this out, but Daphne Keller, who I think is one of the most thoughtful commentators in the United States on the DSA, has observed as well that it's not entirely clear that information produced by intermediaries about the steps that they take voluntarily to deal with content on their platforms, even though the intent definitely seems to be the case that to not have that content give rise to liability, it is not clear, one, that information can't be combined with other information to give rise to liability, or that it will be held out as a sort of a de facto standard, even if it's offered up as something that's just voluntary. So I think there'll be a lot of attention paid to that. And then I'll just close quickly talking about a few comments on the notice of inaction regime, and I think how well received the idea of procedural protections for individuals whose content has been removed, and how important that is to any sort of regime that seems to have legitimacy from the user's perspective, but also some serious questions around alternative dispute mechanisms to resolve those disputes, rather than having, in all instances, I think there's a sense that in all instances there should be recourse to the courts to hear those challenges. And then the one thing that I'll close with, and that is somewhat left open, is just this line drawing between unlawful content and content that is harmful and not unlawful, and what to do about it. Definitely, this seems to be the category of content that's driving much of the debate in the United States over Section 230, and it's not clear that the DSA provides entirely a model for addressing what I think is the most problematic content. So I think in closing, what I'll say is there are a lot of good concepts now in the DSA that will be invoked in the debate in the United States, but some of the largest questions are still left very much unanswered.
Thank you, Eric. Thank you very much. I mean, maybe one comment on that category that's particularly difficult to deal with of the harmful but not unlawful content. The Commission has also released a number of other instruments, not necessarily hard law, but we have the Democracy Action Plan, etc. And we could bring those into this discussion as well, but we'll keep the focus on the DSA today, but definitely a lot to consider there. And thank you for your comments too. I mean, it was interesting, you were talking about liability and then also civil society views. And I mean, if we think of the DMA and DSA as a package, where the DMA has this very prominent B2B component, and it's not that the DSA doesn't have that, but it's certainly been communicated by the Commission as being more explicitly an initiative to benefit citizens. I mean, I was just looking in preparation for this panel today at the Commission web pages that describe the initiative, and you really see what the DSA does for citizens lines sort of first on the list, and there's also a section noting the main points that the Commission sees at what the DSA does for society at large. So you have comments like more choice, lower prices, less exposure to illegal content, better protection of fundamental rights, democratic control and oversight of systemic platforms, mitigation of systemic risks. So big ambitions for this proposal for sure. And on that note, let's open this out to our panel. Sally and Eric, you're very welcome to stay involved with this too. Our panel will provide us firstly with their helicopter reactions to the Commission text for the DSA, and after that, as always in this series, we'll zoom in on some key features. So here we'll look at interplay with other legislation, institutional design as mentioned by Sally, so please stay with us, and without further ado, it's warm welcomes from us to Jean Gagnier, Director of Europe Public Policy for SNAP. Hello, Jean. We also have with us Anna Sola-Bassett, Group Public Policy for Vodafone. Hello, Anna. We have Anja Helset, Public Policy Manager for EU Affairs at Facebook. And I'm sure you'll agree that that's a good calibration of different sorts of market players impacted by the DSA. So a warm welcome to the three of you. On the regulator side, we also have Antonio De Tommaso, Director of EU and International Affairs for Italian regulatory body Agicom, currently also co-chairing the Regulatory Framework Working Group at BEREC, and Camilla Bustani, Director of International for UK Tech and Content Regulator, Ofcom. Very warm welcome to you all. And thanks to all of you for completing a high quality lineup, and really appreciate you taking the time. So let's start. Just to remind viewers that the Slido is open for questions. Please let us know who you are and if you have a panelist in mind for your question. And let's start as trailed with a helicopter view of the DSA. So I'd like to ask each of you whether you could please briefly capture the two main messages you wish to convey in terms of your view on the Commission text, one point of alignment, and perhaps the key aspect of the proposal that you think needs further work in the negotiating process. Antonio, let's start with regulators here. So what are yours and Agicom's top line views on the Commission's proposal?
Yes, sure. First of all, I mean, with your permission, can you hear me? Yes. I would just like to break the rule that you just signed as a speaker, not to go into any introductory remark, but I would just like to thank you and especially Sally and Alexander for the great job done in analyzing the digital service, European approach to digital service. I'm not referring only to the Digital Service Act, but also the parallel work going on the digital markets. And I would just like to flag that this is not just formal thanks, because we as a convergent regulator have been progressively facing broadening our own scope towards digital services, and your reflection, which started in October, and our recommendation are proven to be very inspirational for our daily analysis. And also today's adjustment of the recommendation provided by Sally in the light of the final proposal. So very quickly, not to spend too much time in greetings, what we appreciate, what we like most on the DSA initiative is the initiative itself. We really believe with Sally and Alexander that it is time not just to refresh and review the e-commerce directive, but also to have a more systemic and horizontal approach to the online platform business, and we believe that the DSA goes in the right direction. In particular, what we like is this kind of systemic and procedural take on the issue, which is going through all of the online services which are basically providing content, goods, and any kind of services online, leaving to the sector-specific regulation the details of what is harmful, what is illegal, and what are the specific rules to be applied to each and every specific sector. Third, what we really appreciate is the decision by the European Commission, the proposal to put at the core of the institutional layout a set of independent regulators, both at national level. We see that the features that the regulators should have are very, very clearly designed in line with the best practice which are already existing in the telecom sector, but even more recently introduced in the media sector. And also at European level, because the same characteristics needs to be recognized to the digital service coordinator. And we believe that this is one of the most fundamental tools in order to ensure harmonization at European level. Obviously, what I'm just mentioning as a positive take can be seen also somehow in a different, from a different angle as potential drawbacks, because the regulation is so innovative that one of the main issues we really see in terms of implementation can be the interplay between this horizontal regulation and the sector-specific regulation. Probably we can discuss a little bit further in the second round. I may provide you some examples, but this seems to be one of the areas where probably the legislative process can fix and clarify a little bit. The same goes for the institutional layout. If you go for an horizontal approach, for a systemic approach, you put around the table different bodies at national level with different culture, with different technical and regulatory background, and the same may be replicated at the level of the European Board for Digital Services. And so there's something which is a challenge you may learn, but you also may find some additional layer of interaction and cooperation. Third one, I would just like to flag, and then I will stop, the issue of territorial jurisdiction. Again, in line with the recommendation provided by the CERRE study in December, we see that the issue is brilliantly sorted out when it comes towards the definition of EU jurisdiction towards non-EU market players, using the best practice introduced by the GDPR, and so putting the place where the services are consumed at the center. When it comes to the other dimension of the territorial jurisdiction, so to identify which member states is responsible and which geographical jurisdiction within the EU, to some extent, the interplay drives us to the same issue we already face in the standard Audiovisual Media Service Directive, and this is also another aspect we could clarify during the process. That's all for this first round. Thank you.
Thank you, Antonio. And we definitely will come back to some of those aspects you outlined, especially how this intersects with some sectoral legislation, because I think that was a real key feature of Sally and Alexandre's work from a few months ago. Thank you very much. Now over to Camilla. Hi, Camilla. And we appreciate that you'll be looking at this from across the channel physically and from outside the EU. And we're very aware, of course, of the UK's online harms regime. Originally, I believe the Digital Services Act was meant to be a reaction to this. And obviously now the timelines there have shifted a bit, but we very warmly welcome your views on the DSA as you see them from the UK perspective. Thank you, Camilla.
Thank you very much. And thank you also again to Sally and Alexandre for the paper. So yes, as you say, Lara, the UK is obviously not going to be bound by the DSA and not participating in the negotiations around its adoption, but it's pursuing its own regime around online harms. But even though it's a separate regime, it's going to be quite important that the two regimes are at the very least compatible, because they're likely to be targeting the same platforms, essentially. And it's important to note the two initiatives are at a different stage. So the DSA is already draft legislation. We've seen quite a lot of the detail. In the UK, we've got essentially what is a government policy statement, and draft legislation is currently being prepared. But even at this early stage, we can already start to consider the two side by side and see some important similarities, I think. I think the most important, which Antonello mentioned, is that they're both examples of process and systems-based regulation, which essentially require the companies in scope to demonstrate that they have the appropriate systems and processes to identify and mitigate the risks of harms to users. And I think this focus on procedure accountability of platforms is really important, and as well as the benefits that Sally just mentioned, it also reflects the fact that actually the right answer is going to vary between platforms and also evolve over time. So what is an appropriate system and process is not always going to be the same thing. So I guess what it means is that, and I certainly think this is the intention, is that companies will be incentivized to comply with the spirit and not only the letter of the law. In the EU, the instrument is the risk assessment framework. In the UK, it's the concept of duty of care, but broadly speaking, it's in both cases a sort of form of due diligence obligation. And this is an important shift, I think, in the regulatory model that we're used to, both in traditional comms regulation and in traditional standards regulation. One could say it's a sort of about sharing responsibility for regulatory outcomes between the platforms and the regulators, which is positive, but it does, I think, throw up some important challenges, which I think we're all prepared to engage with. For platforms, I think the fact that there won't be a sort of cheat sheet that they can just tick off to certify compliance, as might have been the case, for instance, under the Telecoms Code and the consumer protection provisions. And this is a, typical of regulatory frameworks that are principles-based rather than rules-based. And then for the regulatory authorities, I think an important challenge is going to be around designing the transparency obligations and connected information gathering powers to support the monitoring and enforcement of these due diligence type obligations. So what data will we need to collect? In what form? How often? Produced for who? For the regulator, for researchers, for users, for shareholders, for a degree of accountability that way. So we're starting from, I think, a position of relative information asymmetry between the regulatory community on the one hand and the platforms on the other. We don't entirely know what we don't know at this point, though we're trying to learn quick. So this is going to be a process rather than a kind of one-off thing. And I think that leads nicely into the question of sort of quite a high-level question of the regulatory relationship. I think both in the UK and in the EU, this isn't going to look like the traditional setup where the regulator sets a rule, monitors compliance, finds a breach, sets a fine, moves on. It's going to be a continual learning process on both sides. And we've heard it described both as a collaborative process or as an iterative process. And certainly in the UK, where Ofcom is going to be producing a number of codes of conduct derived from its duties under the eventual bill, we're going to be regularly revising and tweaking those codes of conduct to reflect, the changes in technology, the changes in the business models, the new harms that might emerge, as well as our own growing understanding of what works and what doesn't. So exciting times ahead. Thank you.
Thank you very much, Camilla. And also really interesting to hear about the iterative nature as you see the DSA. That comes a lot into the DMA discussion. And given that this is package legislation, it's very interesting to see that playing into the UK's approach here as well. Thank you. Right, Anna, I'll come to you now. So as a telco, but active, of course, in the content space and the TV-like content space, video on demand offerings and so forth, Vodafone has been engaged in content regulation debates for some time. How has the Vodafone Group received the Commission?
Sure, thanks. And thank you for putting the event together. And of course, the report, an important contribution to what we see as a really, really fundamental debate for European values, media and content regulation moving forward. For those who don't know, I'll just do some quick facts and stats about Vodafone. So we're a pan-European digital converged telco and TV provider. We have around 100 million mobile customers across the EU, 24 million fixed broadband customers and 22 million TV consumers. So at any given point, we're the second or third largest TV provider across 10 member states. We invested around 60 billion in connectivity, euros-wise, in the past 5 years. And of course, on the basis of that, we've long been a partner with CERRE and many stakeholders in Brussels around the digital single market and all issues, of course, that fall within that around media, platforms, digital and content regulation. And we look forward to collaborating with all of the policy and parliamentary stakeholders around this really important file. I really like to former panelist and the way it was phrased. I think what we see as a really key win in the digital services package is the package itself. Obviously, we were a big supporter of sort of overall policy goals to clarify and harmonize obligations on illegal and harmful content, but also the package preserves some of, I think, the key principles that both us and our platform partners, because of course we have a lot of converged commercial offerings with the platforms and other platforms that aren't on this panel, some of the fundamentals of a free and open internet. So the core principles of the e-com directive have been, we think, really appropriately maintained in a way which preserves freedom of expression and human rights. There's been no changes to the rules around how we deliver content in line with neutrality provisions. There's no general obligation for monitoring of passive or unknown content. And we think that's really, really helpful to getting the balance right between some of the issues that we increasingly see with respect to content online versus the ability to simply have this wonderful open, internet ecosystem that's flourished so much in Europe in the last 30 years. So I think we were really keen to see a balance between guardrails and principle. So in terms of the way it will affect us initially, it's obviously not going to change obligations with respect to TV. That's under AVMSD. Although some of those provisions could be, I think we've clarified a little more. The interplay, we can come to that in a minute. But the baseline of how we monitor content flowing through our networks won't change. The safe harbor provisions for mere conduit have been further harmonized, which we think is really important. And I really, really liked Sally's call out of a couple of different rapporteurs who are now sort of conflating geopolitics and speech. This idea that increasingly there are players in the internet ecosystem, so the platforms who are almost critical national infrastructures of the public square in which we have discourse and debate. It was really nice, I think, phraseology. And so for us, the focus on, I think, transparency of algorithmic selection of content is really, really important, and also reflects obligations which we wear, for example, in our TV services around how we present news and journalism on our TV services. And I think given the dominance in which platforms now play in serving different types of content, not just harmful and illegal content, but general everyday and journalistic content to consumers, we think some of those provisions are really, really important to ensuring that systems remain fair and open, and I would say accurate in terms of ensuring societies are both informed and engaged. I think in terms of what we might look for a little bit of additional clarity on, it's probably similar to the rest of the panel, and I won't go into too much detail, but a high level. I do think we obviously, as an ISP, did try to make clear this distinction between active and passive. So I do think that there could have been perhaps a little bit more of a reflection in the DSA. They recognize the e-com directive, freedom of expression principles, no general monitoring and so on, but we would have, as an ISP, really liked to see a clear distinction between active and passive users of content in terms of how content is monetized as a basic business model. And then that would, I think, help with some of the provisions around actual remedies for certain types of illegal and harmful content online. So the way that those obligations interplay with codes of conduct, the way that regulators will supervise certain different types of discourse online. And then I think as well, we would have liked to see, we of course cooperate with all law enforcement bodies across Europe and globally with respect to notice and takedown obligations we receive and injunctions we receive from law enforcement bodies. But again, we are really excited to see the DSA look to start to try and harmonize these provisions. And we're very, very mindful to push, I think, regulators across Europe to continue to harmonize some of those provisions and provide indemnifications to actors who make best efforts to do the right things with really important law enforcement injunctions we receive. And in that regard, I think we would have liked to see a bit more of a role for sort of pan-European regulators to push really strongly for harmonization in some of these really critical areas. We can come in a little bit more detail later on as well to country of origin specifics. We think there's an opportunity to clarify things a little bit more there, although the package does recognize, of course, the principle, which is a great start. How it will work in practice with the diverging different regulators across member states will be very interesting for us to watch. And then also, again, come to this in some more detail, but the DSA is very clear on distinctions between, for example, VSPs and FOD players and where AVMSD applies versus the DSA. But the way in which certain provisions interplay, so for example, again, the way algorithmic selection requirements work, and just this general idea that we now have two sets of different media regulation looking at different types of services, but increasingly supervised by the same regulators in a manner that's not yet, we don't have enough practice to harmonize the supervision. Recognizing those regulators as well won't initially have a huge amount of extra resource. We're very, very interested to keep an eye on that. So in some very meaty package, lots to look at, extremely exciting. And again, to what an earlier panelist said, you know, what GDPR did for privacy, we are really excited and hopeful that the digital package and the DSA will do for media law and content. So yet again, groundbreaking stuff coming out of Brussels that we're excited to partner with stakeholders on.
Thank you, Anna. You mentioned some of the points to pick up on later, and we definitely will. And notably, just to trail from before, the interaction between this package and existing measures. So let's hold that thought. But over to Anya now. So hi, Anya, thanks for joining us. And Facebook, of course, is a key player in this discussion among those the Commission will have in mind as a very large online platform. What's your view on the DSA in terms of perhaps something that Facebook has received well and anything it's more concerned about and looking to prioritize in terms of feeding into the debate as negotiations evolve?
Yeah, thank you so much, Lara. Indeed, this is one of those proposals that comes and the whole company is looking very carefully. But generally speaking, just to put a really kind of helicopter view on the DSA proposal from Facebook perspective, we very much welcome this proposal. We think it's extremely timely that this proposal is put forward for consideration both by the Parliament and by the Council of the European Union, and it's going to be really helpful for services such as ours, as you mentioned, large platforms with a lot of users interacting daily and posting content, in order for us to really get full clarity as to what are the rules we should play by. And that includes, you know, we generally speaking always highlighted the need to harmonize the notice and action regimes, especially as to what entails a valid notice. This is really a big problem for platforms such as Facebook, who receive numerous notices daily, and obviously we do our best to act upon them expeditiously. But you know, having it clarified, what we think generally makes sense, it's extremely welcome step by the European Commission. Already referred by colleagues here before, and in your recommendation document by CERRE, the kind of clarification that comes in Article 6 about, you know, that you can actually do proactive measures, that you should, if you want, engage in them and have some kind of clarity in the perspective of where it puts you when it comes to liability question. Again, extremely helpful and welcome, and something that we called for in the past as the current e-commerce directive. After all, an instrument that's here in the ecosystem for already 20 years doesn't really recognize so clearly that there are, you know, companies such as ours that really not only want to, but actually are expected to take responsibility and act upon certain types of illegal content in a proactive manner, just in terms of protection of the users and safety of the platform. And we think this is extremely important. Again, there's a lot of transparency obligations that will come, especially for large platforms, but generally for the ecosystem more broadly. This is also reflected in the white paper that we have published in early 2020. Accountability and transparency is one of the pillars that we consider really important in the ecosystem where a lot of takedowns might take place. We already publish our transparency reporting, but we look forward to engage, especially with the regulators after the law is passed, as to how we can improve it. Country of origin taken from e-commerce directive, prohibition of general monitoring, all those principles extremely important from our perspective to maintain of the healthy ecosystem that operates on the objective that we should, you know, preserve as much space for free speech and exchange of ideas as possible. We have to have the kind of coordinated approach in the implementation process. So here again, this is where country of origin comes really into play, and really welcoming as well the kind of effort the Commission put there to also ensure that there is the cross-border cooperation element, which is obviously really important, considering content is, after all, a very often specific to one member state or even regional issues. So there has to be some kind of space for this kind of cooperation. In terms of any, well, red flags, maybe I will just say something that might be surprising to some of you that listen to this panel. We don't per se have any big red flag that we say, oh no, this is absolute no-go. We have lots of questions. We have lots of questions to European Commission, but generally speaking, mainly now to the European Parliament and to member states, but also to regulators who will be really looking into practical implementations of these laws. So obviously, while the law is still just beginning to be discussed by both institutions, we already are engaging and providing some of the feedback, on issues such as how it will work on out-of-court dispute settlement systems. How can we ensure that we actually understand how the audit process will go, who will be the certified institutions, is there anyone already that we could kind of, frame ourselves around? How can we ensure neutrality of such institutions? What about the access to data for researchers? Really important, and we already engage with lots of stakeholders on this point. When it comes to political advertising, how can we draw lessons from that space? Obviously, that's more within EDAP scope, but there's a lot of lessons we can draw from that experience and kind of pass it on to DSA. Recommender system, and the whole issue around personalized advertising. What are we trying to achieve here? What are the goals? And finally, I think this was referred a little bit by some other speakers. While country of origin is there, legal representation is firmly with home, with the representation in the country of your home establishment. The oversight and the setup of governance is complex enough, with participation also of European Commission, the board, other authorities. So in one member state, as we understand, can be more than one authority relevant for the discussion. That can lead to some of the potentially hiccups when it comes to later during that phase of when it comes to work in practice. So no red flags, just questions and willingness to engage, and just generally really welcoming the proposal that is trying to set the parameters for content regulation going forward, and really help us, companies such as ours, many others that operate in Europe, to kind of depart from this very regional, national approaches that make it quite hard to kind of understand how you should approach certain types of behaviors, certain types of content. You're put oftentimes in a very impossible situation as a private company. So this is definitely a welcome step forward, and we look forward to the ongoing discussion that will probably take place in a number of months. Thank you.
Thanks to you, Anya. And it's definitely come up from various speakers, I'm not sure if it's tension, but the coexistence, if you like, of the sensitivities of content and the sort of cultural nature of some content on territory, while at the same time needing or wanting a more centralized approach to also really streamline what we're all trying to do with aim to getting to a common goal. So what I'd like to do next, I'm going to come to Jean from SNAP, and I'll introduce in just a second, Jean, and then I know we have a question for Sally. I know co-author Alexandre de Streel would like to come in, and then we'll move to the next round of questions where we really explore into some of what you've been asking to talk about in more detail. So Jean, hello. Thank you for being here too. SNAP as a multimedia company has also been very engaged in this debate, and also with us at CERRE as we were putting together the study. What are SNAP's main views on the DSA, the main and the main concern at the Commission text? Thank you, Jean.
Thanks, Lara. Thanks for the invitation. I will try to be brief, because I think it's important to leave some time for the second part of the debate today. We also like the DSA intention. When I say we also, I think most of us like the idea. Most of us like the content, like the fact that the clarification of the liability regime is in place, or we also like the desire to maintain the country of origin principle. On this country of origin principle, I think it's very good, that today the DSA complements the CERRE principle by allowing, in certain cases, cross-border injunction and requirement for one regulator to act at the behest of another, which is really good. However, as Anya had said, we think it's important to ensure that any derogation are kept to a bare minimum. Otherwise, country of origin will no longer really work. So we think it's important to establish an explicit mechanism for determining and then maintaining jurisdiction, under the strengthened country of origin principle. But this is not far from what CERRE also advocates in its report. But it's very important, to avoid duplication amongst national regulators, as well as sorry, the need to avoid forum shopping. So this is really, we think, the positive part of the DSA. We can share a lot of positive elements, but I think it's more interesting to share what could or should be improved, because I'm really concerned about the fact that the DSA objective is very ambitious. And to some extent, part of this ambition is left aside in reality when we look at the text today. First, I think it's always important to know what we want to achieve. It's very important to never forget the end goal of the DSA. The end goal of the DSA, one of the most important goals of it, is really to improve the safety of consumers in demanding very large platforms to be more transparent and to limit the risk generated, to drastically limit the risk. It's not a small limit, it's a very important limit of the risk. And this is a very important and welcome target. But my fear is that today, the focus is no longer on the what. Instead, focus should be more on the what has to be done to achieve something, not on how the platform have to get there. And today, the DSA is not looking enough for a principle-based approach. It's very more about to be a very prescriptive-based approach and missing the ambition of what the goal should be. And this is not far from what Sally said in the first part of the discussion. Because when we think at what Sally said, when she said that not all services carry the same risk, and what basically the CERRE report states, and I have the CERRE report with me, I think this is very right or very correct. They say that digital platforms that by their nature pose a greater risk should be subject to more obligation than lower risk ones. I think in saying this, everything is said. And in looking at this, we can really see the ambition of the DSA that has been missed. Because today, the DSA fails to take the variety of risk into account. Of course, the DSA creates a very large platform, but I think this is a misguiding good idea, because the DSA approach or very large platform assumes that one, all the very large platforms generate the same type of and volume of harm. Two, that all very large platforms have taken similar safety precaution upfront. Three, that all very large platforms have almost limitless resources. And four, that all very large platforms are highly profitable and that they are in some way generic and equals in the market. We can, of course, quite easily see that those assumptions are misleading. So I think it's crucial that this instrument doesn't prevent also the growth of challengers company in Europe, not far from what CERRE state as well, when CERRE says that the DSA should not impede and on the contrary, should encourage the development of startup and scale up in Europe. This is very correct. Because today, in fact, by imposing a very large number of administrative constraints on all very large platforms, the DSA misses some of the reason why. Again, I'm coming to the why and how a platform generates illegal and harmful content. So to address this paradox, all the risk should be read with a certain approach in mind. And here I will explain very quickly what Camilla explained very well when she made an allusion to the duty of care, because I really think that to address this paradox, all the risk for very large platforms should be read with an appreciation of proportionality for the scale of harms, the size of the platform, the mitigating factors to reduce harms, or the underlying business model of the platform and the way the platform approach risk, the way the platform is managing the risk. So I think that this is really something I wanted to start and to insist on. Later on today, in the second part of the discussion, I can explain and I can develop more. I think what today should be discussed again, which is basically the 45 million threshold. But this has been very well addressed before by Sally and by Eric. But I just would like to conclude in saying that the DSA should develop this accountability approach based on proportionality, as well as with an appreciation for the position of a smaller startup and medium-sized challenger companies. So this is just what I wanted to say as an introduction. Thank you, Lara.
Thank you, Eric. Jean, sorry, and time is flying indeed, but there are questions from the audience, and there's one from Sally here from, I'll try my best on pronunciation, Frana Maroevich from the Internet and Jurisdiction Policy Network. Sally, Frana asks you that platforms will need to remove illegal content, but as there are different standards in EU member states, will this mean that the most restrictive standards may prevail?
Okay, first, greetings to Frane, who used to be also at the OSCE representative on freedom of the media. So I can understand this concern for a race to the bottom, so to speak, in terms of standards, because that was a big concern with the AVMSD back when it was all even television without borders. I think one of the things to remember here is that content moderation is already done, specific to particular areas. The services that are here can correct me if I'm wrong, but they're already taking these different things into consideration. And one of the things that you have in the DSA is the requirements for people to be informed when their things are removed, or when access is denied. And in that, one of the standards that the DSA says in terms of the content that this information has to include is whether or not that was a global removal or whether it was only for a specific area. So in some ways, actually, we would be able to have more oversight over the extent to which that might be any kind of a problem. And I think actually, it raises a point that that Eric made earlier in terms of the need to ensure that we don't end up foreclosing on competition. And so you could easily see why this sort of level of nuanced content moderation and detailed informing of users when it takes place might be something that is a bit burdensome for small or medium companies. And that's why, we need to get the proportionality right. We need to get the line drawing right in terms of who's going to be obligated to do everything. And this is one of the things that I think was across the board an obligation for all services. And I think that's something that's going to require, I think, talking to services, looking what's actually being done, the extent to which there are geographic differences, and how they're making those distinctions and able to inform people.
Sally. Alex de Streel, co-author of the CERRE paper. Hi, and I know you wanted to come in on a couple of points. If we can do that briefly before moving on to round two, that would be fantastic.
Yes, thank you very much. Good afternoon to everyone, and thank you very much for the comment you provide to us. I wanted to come back to two points which were made in the comment, and which to me are very important. The first is the relationship with other EU law, and in particular the Audiovisual Media Service Directive. I mean, that has been mentioned several times. My worry is that I think there is some still area which is not clear, and we need to clarify that, because it won't just be a kind of conflict between two EU rules, but it also will be a conflict between two enforcers. And in particular, for the very large online platform, as you know, the enforcer may be the Commission. So we will have, on the one hand, a national media regulatory authority enforcing the EVMS, whatever the size it is, which I think personally is not a good approach. And we have seen the failure of that in the GDPR. I think for the very large online platform, it's better that it is a European regulator. But okay, that's the system that you have in the EVMS, and I don't think it will be changed soon. And then for the DSA, for the very large online platform, and we may discuss, as Jean was mentioning, whether the trigger is right or wrong, but at least we will have a specific category there. We will have possibly the Commission. So I really think that in a way, if you want, the conflict between rules will be amplified by the fact that you will have a different institution which are not even part of the same, let's say, legal framework or country which will be in charge of that. So that's the first point. And I think really I would urge the legislator to clarify as much as possible the link there. The second thing is, and I think Camilla was, as very often or always, very clever in her comments in saying that the enforcement will be key and we will have to change our culture of enforcement. And I think on that, the DSA is going in the right direction, and I would say in a much better direction than the sister DMA. And we have discussed that in other seminar at CERRE. But I think we need to really do two things. First, to have everyone around the table, as Camilla was mentioning, and that's what we have called also in another CERRE paper, to create an ecosystem of oversight, where you have, the authority is not there with the through and imposing the through or the good solution to the platform, but it's together. I mean, the regulator is there to stimulate everyone, the platform, the user, the civil society, to work in the public interest. And I think that's more or less right in the DSA. But then we will make mistakes. Obviously, everybody will make mistake in that regulation because it's new. Platform will make mistake, user will make mistake. And so what is very important is to learn from that mistake, that you have a kind of a feedback loop where from experience, you improve the system. And there, I think we can also, the legislator on this feedback loop could improve a little bit the system. I think on the first point, to have everyone around the table, that's right. To have this positive feedback loop to improve from experience, I think that can also be a little bit improved.
Thanks so much, Alex. Segues nicely into the next round that we want to discuss. I mean, we appreciate also fully, not just because of AVMSD, but other regulation also, that there are many different national regulatory bodies at play here, and even many regulatory networks. I mean, we can think of BEREC, ERGA, the EDPS, and some of the companies involved, even here on this panel, they're classified in multiple ways. They're video sharing platforms, they're internet services providers, say, and we can appreciate in this debate that it's difficult as companies prepare to take this legislation for them to even know where to go. So with this in mind, how do we think that the DSA proposal interacts with the existing rules and frameworks that we already have to implement? AVMSD, GDPR, and so forth. What might be the impact of the DSA on the institutional design, as we've been discussing, and the new relationships that will need to be built within national regulatory authorities and different stakeholders. And not to overcomplicate things too much, but another piece of regulation at play that a viewer has pointed out, we have Anna Bigor pointing out to regulators that auditing moderation algorithms, that there's potentially a loophole in the form of the Trade Secrets Directive, Article 31. So another example of sectoral regulation here. Okay, let's switch up the order here. Maybe Anna, I'll come to you first this time.
Thank you. A nice, easy, simple, short one to start with. Lots to unpack there. I think it's really clear for us that the DSA obviously attempts to distinguish sort of traditional types of content that's, monetized through TV platforms or VOD from online content, just because of the nature of certain types of, harmful and illegal content that the DSA is trying to deal with. And because of the very nature of again, this sort of public town square that platforms are increasingly playing in just everyday sharing of news and different types of journalistic content. So in our mind, that's pretty clear, that distinction, but we are really interested to see how regulators continue to interpret that. I mean, there are provisions with respect, as I said earlier, to algorithms that exist between both, the way that they would be maybe supervised differently where the types of content is the same. So say we're talking about news or current affairs content, could be an interesting one. There's also very clear provisions that we obviously take very seriously in AVMSD around children's safety and children's protection. And given the policy intent of the DSA, we query how that will be sort of supervised over time, given that, again, content is very specific to different member states and ideas of how aggressively to police in that space are very different between countries. Country of origin, again, is always difficult. We also don't want forum shopping, and we want clarity, particularly for law enforcement injunctions. And I think, again, we had actually preferred a more centralized form of oversight. You know, it is good that the DSA reflects the model, at least in the AVMSD, so it isn't sort of race to the bottom, but at the same time, sort of given the policy issues that the package is trying to address, we are hoping that at minimum, some of the regulators you flagged, in particular ERGA, we think they have a really, really big role to play. For example, in providing, you know, harmonized guidance about codes of conduct and the way that member state regulators can roll them out. And again, you know, personally speaking, and as an ex-radar, I also am not concerned, but mindful of the impact of resources as well, right? So these are huge new issues. There's a lot of questions around, to Jean's point, the what of what we're trying to get at, and not just the how. We don't want process above substance and supervision. And at a national level, but also at a European level, I think there's going to be a lot of conversations between regulators about how to supervise these issues in a way where it's not just about donking people over the head with huge fines. We actually want to move to a world where some of the nastiest stuff online is dealt with really swiftly and appropriately, while at the same time allowing a free internet to flourish. So lots of interesting times ahead, and the way that regulators deal with that resourcing question, I don't know. And then again, as well, we really do see this as precedent setting for other authorities globally, and we are not worried, but I would say, you know, on these sort of content issues, we'd like to see a race to the top. So we would like to encourage, you know, international authorities, legislators, parliamentarians, regulators to look at these as sort of a precedent setter. We don't want a fragmented system around the globe, given the sort of seriousness of the issues that these are dealing with, the seriousness, sorry, of the types of content that this package seeks to address. Very interesting times ahead. I'll keep saying the word interesting. It's a word that covers all sins. So.
Thank you very much, Anna. Thank you. Yeah, you pointed to the Brussels effect there, and I think certainly quite a catchy sentence to keep in mind on not privileging process above substance when it comes to supervision. Thank you. Camilla, what about you?
Thank you. I mean, we're in a funny situation because even though we're no longer in the EU, I think we're one of the first to actually begin implementing the VSP provisions. So in fact, just last week, we published our draft guidance for VSPs. And I think because we see this very much, as Sally suggested, as a sort of pilot for online harms regulation more broadly, which is going to take a few years to get in place in the UK, we are sort of trying to anticipate a little bit the types of things that the online harms regime will be sort of focused on and will require of stakeholders. So for instance, we've got provided sort of a list of the types of protection measures that VSPs might put in place to meet the requirements of the VSP framework, and they range from things like terms and conditions, flagging mechanisms, parental control systems, age assurance systems, that kind of thing. But also we kind of go a little bit further and suggest that they might consider things like a safety first approach, engaging with third parties they might not normally engage with around sort of charities and NGOs, academic experts, but also in particular looking at risk management systems. And that's a sort of, anticipating the sort of risk assessment frameworks of the duty of care regime that's going to come into force in a few years' time. I think it's interesting in this respect. It's sort of, I guess, one thing that Brexit has made easier for the UK is being able to sort of more freely make these choices about which regulator is doing what. But when I look at the proposal of the DSC, of the Digital Services Coordinator, I find that really, really interesting and quite a positive idea, because I mean, on the one hand, you could assume, I think a lot of people did assume that ERGA and the audiovisual regulators are going to be the ones in scope for the DSA. They're going to be responsible because it's about content. But the DSC proposal suggests it's not necessarily the case. And I think what the DSC proposal does is that it offers an opportunity for an inter-regulator dialogue at the national level that might not previously have existed. Between the traditional audiovisual regulator, the data protection regulator, maybe an electoral commission, if they're relevant in relation to disinformation. I don't know. Parts of the, sort of police. I don't know. But in the UK, we have a really interesting development that we launched, or we sort of announced the work plan for a couple of weeks ago, which is bringing together the CMA, which is the competition regulator, the ICO, the data protection regulator, and actually the Financial Conduct Authority into something called a Digital Regulators Cooperation Forum. And it's an informal network at the moment. It doesn't have legal status yet, or it certainly doesn't have powers, but it's a forum to make sure that we are, as much as we can, taking our own respective regulatory decisions, not in isolation from the very relevant adjacent regimes that the other regulators are responsible for. So maybe the DSC model is an opportunity to trigger that kind of dialogue at the national level. It's not straightforward. It will be, it will raise its own challenges, I think. But in the long run, I think it's necessary because even within, I mean, we've been speaking VSP and DSA, but there's also GDPR, and there's also, quite a lot else, DMA, for instance, which will have, decisions within one umbrella might have an impact under the other, and the idea is to try to be as coherent as possible.
Thank you so much, Camilla. Jean, how about you?
Yeah, sure. Can you hear me? Sorry. Yeah, great. No, I just wanted to, let me be very quick because I know that we have a few things that we would like to discuss on later on today as well. But basically, I think we all agree on the fact that we need to be very careful about the fact that there is an increasing number of regulatory bodies involved in regulating digital market, and as well as the number of service provider definition in EU instruments. We, of course, mentioned AVMSD, but I can, quote several others like copyright, P2B, ECC, so many of us. And the interplay of DSA and all these existing EU instruments is definitely something that can be a problem that has to be clarified. So I would just say two things to be very quick. We have to encourage the Commission to avoid creating duplicate requirements for services that are already covered by existing EU instruments like AVMSD. And two, the Commission should provide a clear guidance for those companies that are covered by multiple EU level instruments and multiple regulatory authorities, members of BEREC, ERGA, EBDS, etc. So yeah, that's it on my side, and I can speak later if you want, but wanted to be crisp and nimble.
Thank you. Yes, avoiding duplication versus streamlining are very important there. Antonio.
Yes, many thanks. So many interesting input. So I will try to keep my second round a little bit focused according to your question. I mean, what are going to be the challenge in terms of institutional interaction for the NRAs? And I would say it is going to be really a challenge. We are a convergent regulator, are already in charge and in contact with some digital players we are going to be engaged with within the DSA. However, the situation is going to be very different. We all know, picking up the audiovisual media service, that there are still some rules on video sharing platform, but on some specific aspects of their business. And on top of that, the approach is completely different because there are no enforcement rules, no sanctioning. So in the end, everything will change. The pattern of relationship will completely change. And as Camilla's pointed out, there are many new jobs that we have to develop within the DSA as it is now. Let's say asking data, understanding which data we need to ask to do our job, running investigation, getting in touch with other NRAs within the national framework. So it is going to be a challenge. And again, I would just like to stress that we are happy to see that somehow the regulation, the draft regulation underlines this and provides once again for a clear request to member states to equip NRAs with sufficient human and financial resources, which is also important to have the sufficient and the adequate skill to run this new job. The second point, the other challenge is the international dimension. I would say the cooperation which NRAs are expected to engage both at national level and at European level. I'm with Camilla when she said that in the long run, this is unavoidable, but still I believe that in the short run, it will be a real challenge, especially if we see that within the DSA, we are not going to put around the table NRAs with, let's say, similar culture and similar tools, but the kind of goods and services which are provided online are quite different. So in the end, there should be someone as digital service coordinator being in whatever national remit, having to develop contacts with national bodies that we haven't really get in touch with in advance before. So this is something which is really a challenge for the short run. In this respect, I would just like to pick up also some of the ideas that have been mentioned by, I guess, Alexandre, and for sure, lastly, by Jean. There are still some groups and cooperation patterns going on in several areas under the Digital Service Act, and I think it is worthwhile to use those groups and to start from them. I remember that in the recommendation, in the original recommendation by the CERRE in December, a clear role and a possible clear role was called for ERGA. In the cooperation, and I think that this is also some one of the areas that we can exploit. Obviously, it's too early now to find solution to such a complicated patchwork. How the digital service institutional design is, but in the end, I think that we should bear in mind and consider these options also to try to draw some conclusion. I would also like to finally pick up another suggestion by Alexandre when he is basically pointed out the need for a, so to say, innovative approach and cooperative approach. So the regulatory dialogue that it needs to be enshrined into the DSA, and if I'm right, is basically comparing with the bilateral dynamic that is in the DMA. Also in this respect, I think that it would be useful to take stock of the experience we already have, this time not in the media sector, but in electronic communication sector, where basically with the mutatis mutandis situation, in the end, we have a similar approach within the market analysis, where we have the possibility to get involved other market players in a multilateral regulatory dialogue, and not just the bilateral contact between the regulator and the digital player, which is bound to be subject to the rules. I guess I have already anticipated some of the final takeaways, but I would just like to stress something at the end if I have time.
Yes, we're going to whip round for final takeaways, and we're going to have to be incredibly brief. But Anya, I am conscious that we still haven't come to you for this round. So some very quick thoughts on this round of the interplay, and then we'll move on to a quick final round. Thanks.
Yeah, absolutely. I think a lot has been spoken by my fellow panelists, so I will not surprise anyone when I say, yes, we are looking at the interlinks between, of course, DSA, AVMS, the core links there, as we are just covered by AVMS, and we will obviously be covered by DSA. there's also a lot of interlinks in some provisions, right? There is a request to act against illegal, well, request orders actually to act against illegal content, something that's also in the terrorist content regulation. There is requests or orders for information by law enforcement, something that's already in e-evidence regulation. All those regulations incentives are either already implemented or during implementation process. So it's just a plea that obviously when we will be engaging on DSA, that we kind of reflect as the whole framework comes together. That you have to remember that DSA is supposed to be this horizontal instrument. So if you want to make exceptions, you need to kind of reflect on it right now, just so there's no difficulties later in the implementation phase.
Thank you, Anya. Gosh, e-evidence, I mean, there's more of this regulation that comes into play here that keeps coming. We could even think of other regulation in the pipeline. Someone talked about DMA, the future AI framework. There's really lots of it to consider. Right, we only have a few minutes left, so I'm very sorry that we're going to have to be very brief in this last round, but I did want to ask panelists for their top line takeaways, and perhaps here, if we could focus, the CERRE report did talk about responsibility with limited liability. We're very aware of many types of self-regulation, co-regulation in play already in the area of content regulation, codes of conduct. So, you know, how do we enact proportionality is maybe the key thing. And if I could ask you all to just very quickly sum up, I'll come to panelists first and then Eric and Sally at the end before closing. Thank you very much. So Jean, let's start with you.
Thanks. And this is really, I think, the part I like best in the CERRE report. So I can speak for hours about this. I will speak in 1 minute. What I basically think, sorry, what I basically think is that this part is very important because, as Sally said already, not all services carry the same risk. So it's important to promote in the DSA an approach where platforms that take stronger mitigating steps in terms of user safety would see their potential liability reduced. So basically, I think that when we think about responsibility with limited liability, it should mean that platforms that take the strongest mitigated good faith step, like, you know, more monitoring, curation of our privacy and safety by design, so that are taking more good steps in terms of user safety, should see their potential liability exposure reduced. And this is something I wanted just to briefly link with the definition of a very large platform, because I think that this definition is totally arbitrary, and we know that already. The 45 million threshold is disconnected from the reality of the business. So I think that we should focus not only on this single quantitative threshold number to determine the harm caused by a given platform, but the definition should also improve with some qualitative criteria. And those qualitative criteria should take precisely into account this potential liability reduction with having in mind the good behavior of the platform, the good faith of the platform. Just to finish, I think this would incentivize more socially responsible companies. And the socially responsible companies is an interesting concept that was in the DSA first, and that has been discussed by members of the parliament. So I think it's important to look at companies that are taking good faith steps to make that platform safer via an additional monitoring or safety by design approach. And from this, we should benefit from a reduced liability exposure. I just stop because I know we don't have that much time, but this is a very important topic, and maybe a topic that we can discuss in another debate in the months to come.
We'd love to do that. Thank you, Jean. And yes, indeed, about the socially responsible companies is definitely another point to pick up soon. Anya. Anya?
Oh, I'm sorry. Yeah, so just to close, I mean, it's hard to summarize everything that has been said, but I think from our perspective, it's just very key that in the upcoming discussion, we really try to focus on helping later the European Commission with the implementation. Some of the provisions I flagged in my intro remarks are really something that we, you know, as a team struggle with understanding how it will be implemented. Implementation process is really, really short. and we receive signals that, you know, the expectation is that we will be up and running almost when the proposal will be in the official journal. A lot is left as well for the guidance from the European Commission, which obviously is the solution one way or another. But I think as much precision as possible to be added into the regulation, especially on those very new ideas, out of court settlement, but other issues such as trusted flaggers, we haven't talked about it, the provisions around know your customer, who do you mean really, which type of platforms, all this is really important to receive some kind of you know, guidance for us as we prepare for implementation, because we understand that we need to be ready. Thank you.
Thank you, Anya. Camilla, on the responsibility with limited liability, proportionality, any closing remarks based on that and your takeaways in general?
I guess one of the differences between the DSA and the Ofcom policy, government policy on online harms, is that our category 1, for instance, which is the equivalent of the VLOPS, is not just determined on the basis of a quantitative criteria like number of users, but also around functionality. So it's a more subjective assessment, and I think that's a really important mechanism for exercising proportionality in regulation. And then the other thing to say is that I think the expectation is that under the approach, and perhaps scope for this in the EU approach, is that because it's a system based around risk assessments, the required risk mitigating actions will be linked to what the risks are. So if it's a low impact, large but low impact platform service, then it will assess a certain level of risk, and the mitigations will be, you know, of the same scope, let's say. So there is potential other route for proportionality.
Thank you so much, Camilla. Anna.
Thanks, and thanks for all a really interesting discussion. I mean, just briefly on codes of conduct, and then to sum up to your last question, Lara, I mean, we like the co-regulatory approach. We think there's a big role for ERGA. Vodafone has long tried to lead in its sector in this field. We've done transparency reporting for years. Voluntarily, we have certain block lists for known content. When it's on our networks, we're notified by law enforcement through appropriate injunctions. So I really liked Antonio's focus on a cross-sector approach where we work with regulators in a way to ensure that systems of supervision actually get to the outcomes that we're all trying to get to in terms of having a safe but open and factual internet online, while explaining sort of some of the technical specifics. So for example, you know, Australia tried to do some work around blocking some websites with ISPs, and it ended up, for copyright reasons and safety reasons, sort of blocking 1/3 of the internet accidentally overnight. So ISPs worked as a very close partner there on some of the technical measures. In sum, I think it's fair to say this package is coming, and I think we know it's all coming. And I think Jean's idea of limited liability is one to potentially explore in a future event. But I would really like the panelists and like industry to focus on the entire reason we are looking at these sort of reforms is ultimately to protect a free and open internet, and also to protect consumers of content online. So content is still clearly king. I don't know who the queen is, if that's platforms, ISPs, the regulators, probably Lara sitting there in the middle of CERRE getting us all together. But you know, if we look, for example, at some of the obligations other regulated enterprise sectors wear, for example, if telcos argued for a lesser actual legal statutory liability, should we not comply with, for example, our net neutrality provisions, or some of our, you know, obligations to deliver to rural and regional communities? You know, if banks argued for less actual like legal liability in a technical sense based on, you know, not fulfilling their prudential obligations or their obligations on money laundering or consumer fairness, I think it's a little, I think that it's a perhaps quite a strong approach to take. So I wasn't clear, Jean, if you were saying that perhaps it's all in the supervision of the firms, but rather than the actual statutory obligations. I think that would perhaps be going a bit far, given the package is not even passed yet. But to that point around the way that platforms and the TMT sector as a whole, we are across, you know, we are tech, media and telco, when we're not just sitting there in segments, in the way we work as a whole with our regulatory partners as a community to work through some of these really fundamental issues around speech. I think there's something for us to all do together there quite closely to ensure that, again, as I said earlier, this doesn't turn into a question just of process for reductions in liability, but actually leads to good outcomes for both protection of and preservation of free speech and consumer protection online. I think that's something we've all agreed that we wanted moving forward globally.
Thank you, Anna. Thank you very much. Interesting views on the monarchy of this era here. I'm definitely not the queen of timekeeping today because we are running over time. But let's hear from Antonio and then Eric and Sally very quickly on their takeaways before closing. Thank you for bearing with us, viewers.
Yes, very quickly on proportionality, it seems to me that basically proportionality is identified as one of the main pillars of the DSA. So we basically welcome the approach for a gradual increasing of the regulatory burden depending on the level of control, keeping basically the structure and the distinction of different players which have been developed during the implementation of the e-commerce. We also see basically and welcome the idea of identifying the very large online platform based on the size, on the audience reach, because it can be one criteria, but I also see the point raised by many of the speakers today that probably we should also try to distinguish a little bit what is an economic impact and what has a social impact on some fundamental rights. And so this is also an additional set of criteria that could be developed during the process or even later on by means of the Commission Implementing Act. I would also like to flag the importance of the time factor, because very often in such a ever-evolving digital world, if we speak about the size on the audience reach, things may change overnight or anyway very quickly, and so probably we should try to consider also some more flexible criteria in order to assess the size. If we are speaking about the reach, because probably the process should be very quick in order to take into account the changing of the environment. Finally, and this is basically the final remarks, again, we think that the European Commission has done a good job in putting this DSA draft regulation at a very timely moment, and also the level of ambition. We see that they are basically, let's say, have the ambition to have to set a standard globally. It's really welcome. There are some areas that we clearly emerge today that needs to be fixed. From a regulatory perspective point of view, the most important one is the interplay between the horizontal and the sector specific. So which is the rule applicable and who applies the rule. Also the level of responsibility between the national and the European level for the very large online platform is something which still needs to be clarified. But we are not starting from scratch. And again, I would just like to underline the contribution that the individual NRAs who are already working at this topic and collectively within the regulatory cooperation body could provide to the regulatory process. Thank you so much, Antonio.
Eric, thanks again for having joined us today. What are your key learnings from the discussion?
Yeah, first of all, thank you for having me. This has been a fantastic discussion. I've been really intrigued by the conversation about proportionality. That seems to be something that is a main theme of the report and main theme of this conversation. One thing I kept on coming back to was a comment that Anna made a few times about how certain online services or platforms can function as a public square or a public space, and other people refer to them as sort of essential facilities. And we've just been through a unique experience in the United States where the president's own personal Twitter account was deemed like a public space from which he could not block other people without violating their First Amendment rights. And then he himself earlier this year was removed from Twitter and Facebook. So somewhere in all of this conceptualizing, there seems to be an assumption that we sort of know when platforms are public spaces when they're essential facilities, but there's some sort of, in all cases, at least in the US, a clear conceptualization of when that is the case. And to the extent that there are certain requirements or certain types of co-regulation and self-regulation that are more appropriate with respect to those public spaces or essential facilities, more clarity about when we think a platform has reached that threshold, I think would be helpful in informing the conversation about proportionality. Thank you.
Thank you again, Eric. Sally, last word to you, and then I really will close. Thank you again to viewers for staying with us longer.
Thanks to everyone for the really interesting discussion. I think it's important to remember the default is still exemption from liability. And so what we're building on top of that is the extent to which a proportional level of responsibility is built into a system. And so I think we've highlighted here where we're drawing the line on what is that, you know, special big category of platforms is going to be crucial. And the risk-based approach, I think, is great. If we look at it, that is where the legal but not maybe harmful stuff comes into play, because the risk assessments are expected to be done not just on illegal content, but also risks to fundamental rights and risks to society more widely, public health, etc. And so where we actually draw the line around who's doing risk assessments exactly for what, and then against what are they going to be measured in terms of holding them to account, clearing up the role between the auditors, the regulators, and the pan-European level stuff. We still need a lot more clarity on that. And I agree with the idea of trying to work a lot of that stuff out now so that it doesn't end up stymieing the whole purpose of things when we get to implementation. So I'll leave it at that. Thank you.
Thank you, Sally. Thanks again to all viewers for all your attention. What has definitely not been a run-of-the-mill DSA event. To all our fantastic speakers, I mean, so content-packed that I refereed the match into extra time. And to the CERRE team, of course, for all their hard work behind the scenes to make this happen. Please do consider signing up to the free CERRE newsletter for details on our high-level closing event, apart from anything else, which, as I mentioned, we have a 4th of May date we're hoping for, and that we're really looking forward to. Hope to see you next time. Wishing you a healthy and productive few weeks despite restrictions, and a very nice evening. Thank you again.